Let's examine another pressure point that's pushing the food industry toward change: legal liability and consumer litigation around food dyes and misleading labeling practices. Because while regulatory action has been slow, the court system has become another venue where these issues are being contested, and the outcomes are creating real financial and reputational consequences for companies. The litigation landscape around food dyes falls into several categories. Misleading labeling cases are probably the most common. These lawsuits typically allege that products marketed with health-forward claims or natural imagery actually contain artificial colors and other synthetic additives that contradict the overall impression the packaging creates. The legal theory is that reasonable consumers are being deceived by the disconnect between front-of-package messaging and actual ingredient lists. Court records show dozens of these cases filed over the past decade against major food manufacturers. Some have been dismissed, some have been settled, and a few have proceeded to trial or class certification. The settlements, when they occur, typically involve companies paying millions of dollars to class members and agreeing to change labeling practices, though often without admitting wrongdoing. One notable case involved a major cereal manufacturer whose products featured fruit imagery and made with real fruit claims prominently on boxes, while the actual fruit content was minimal and the products contained multiple artificial colors and flavors. The case was settled for several $1 million, and the company agreed to modify its labeling. Another high-profile lawsuit targeted fruit snack products that showed pictures of fresh berries and other fruits, but contained artificial colors, no significant fruit content, and high sugar levels. These cases hinge on state consumer protection laws and the legal standard of whether a reasonable consumer would be misled. Defense lawyers argue that consumers can and should read ingredient lists, and that technical accuracy in specific claims should defeat false advertising allegations. Plaintiff lawyers counter that companies deliberately design packaging to create impressions that the fine print contradicts, taking advantage of the reality that most consumers don't read ingredient lists carefully. Some courts have been receptive to plaintiff arguments, allowing cases to proceed beyond initial dismissal motions. The potential for class certification means these cases carry significant financial risk for defendants even before trial, because they could represent millions of consumers and hundreds of millions of dollars in potential damages. Beyond labeling cases, there have been attempts to bring health-based claims alleging that artificial colors cause harm to children and that companies failed to warn consumers of these risks. These cases are much harder to win because they require proving both that the dyes cause specific harm and that the manufacturer had a duty to warn consumers about risks that aren't officially recognized by regulators. Most health-based claims have been dismissed, but they generate negative publicity for defendants and keep the issue in public consciousness. Regulatory letters from state attorneys general represent another form of legal pressure. Several states have investigated whether certain products' labeling violates state consumer protection laws and have sent warning letters to manufacturers. While these don't always result in lawsuits, they create pressure for voluntary compliance. Attorney commentary from consumer rights lawyers emphasizes that litigation serves multiple functions beyond just winning money for plaintiffs. It forces transparency through discovery processes where internal company documents must be produced. It generates media attention that increases consumer awareness of issues. It creates financial pressure that makes reformulation more economically attractive than ongoing litigation exposure. And it establishes legal precedents that shape industry behavior going forward. The case timelines reveal that food litigation moves slowly, often taking 3 to 5 years from filing to resolution, but the cumulative effect of dozens of cases creates ongoing pressure. Companies must dedicate legal resources to defending multiple lawsuits simultaneously, face discovery costs and potential embarrassment from internal documents being made public, and risk adverse judgments or settlements that cost millions. The takeaway is that legal pressure, while not as direct as regulation, is becoming another lever pushing industry toward cleaner labels and removal of artificial additives. Companies are starting to factor litigation risk into their reformulation decisions. When executives weigh the costs of reformulating versus the costs of ongoing legal exposure plus potential settlement payouts, the economics of removing dyes start looking more favorable. Consumer lawsuits are an imperfect mechanism for driving food system change. They're slow, they don't affect all companies equally, and they depend on state laws and judge interpretations. But in the absence of strong federal regulation, litigation has become one of the few tools available to hold companies accountable for misleading practices and to push for better transparency about what's really in our food.